Do private military companies have ROE? Have you ever wondered if private military companies have rules of engagement? This question is quite important in understanding how these companies operate in conflict zones. Let's break it down. Private military companies, often referred to as PMCs, do not have formal rules of engagement like national military forces do. Rules of engagement are official guidelines issued by military authorities. They define when and how military forces can engage in combat or use force. These rules ensure that military operations follow national policies and international laws, including International Humanitarian Law. PMCs operate under contracts with states or other clients. Their personnel are usually not uniformed members of a country's armed forces. Because of this, the formal rules of engagement that apply to national militaries do not automatically apply to PMCs. Instead, PMCs may have specific rules for using force, which are outlined in their contracts. These rules can vary based on the operation's context, the laws of the host nation, and any international legal obligations. From the perspective of international humanitarian law, PMCs have a complicated legal status. If personnel from a PMC are integrated into the armed forces of a party to a conflict under national law, they may be considered combatants. In this case, they would be subject to the law of armed conflict and the rules of engagement that apply to those forces. However, most states do not formally incorporate PMCs into their armed forces, which creates ambiguity regarding their legal status. When PMCs operate in conflict zones, their use of force is often regulated through various means. These include contractual provisions that specify when and how force may be used, such as in self-defense or defense of others. Additionally, PMCs typically have training requirements that cover weapon handling and limits on the use of force. Coordination with military forces is also essential. This helps manage operations in conflict areas and ensures proper identification and communication. PMCs must comply with applicable laws of the host nation and any status of forces agreements that may be in place. Since PMCs do not have a universal or standardized rules of engagement framework like national militaries, their actions are governed by a mix of contractual rules, national laws, and international legal obligations. This situation can create challenges for accountability and the consistent protection of civilians during armed conflicts. In summary, while PMCs may operate under specific contractual rules regarding the use of force, they do not have formal rules of engagement like regular military forces. Their compliance with the laws of armed conflict and the Geneva Conventions largely depends on their legal status, the terms of their contracts, and the oversight from the contracting states. This legal complexity highlights the need for clear regulations and oversight to ensure that PMCs respect humanitarian principles and protect civilians during times of war.